Christina McKelvie, followed by Dean Lockhart. 5 minutes, please, Ms McKelvie.
Thank you very much, Presiding Officer. The need for the continuity bill is pretty much unquestionable to me, because there are many areas around EU directives and laws which are incorporated into primary legislation that bother me greatly. And these are child sexual exploitation, trafficking in human beings, domestic violence, sexual violence, child grooming and pornography, all of which, in my opinion, go further on protections in Scots law than they do in their UK equivalents. And that bothers me greatly. The Victims' Rights Scotland Act 2015 is another such example. They go further in Scots law on protections of people than UK law. The continuity bill for me enshrines into Scots law the Charter of Fundamental Rights, of which we've heard much about today. And my reading of Adam Tompkins' Amendment 98 seeks to give no strength to the Charter in Scots law, or even a position. And that worries me greatly. I'm going to get on to that point. In Stonewall's briefing to the House of Lords on amendments to the Withdrawal Bill, that the Stonewall briefing tells us, and I'm going to quote from the briefing, retaining the Charter of Fundamental Rights. Clause 5.4 of the bill makes it clear that on leaving the EU, the Charter of Fundamental Rights will no longer apply. While domestic law and the European Convention on Human Rights provide similar rights, the Charter offers an added layer of protection. Stonewall tells us that they are deeply concerned that removal of the Charter will result in the dilution of rights, and strongly urges peers to support amendments to retain. Amendments the opposite from Adam Tompkins. Yes?
Adam Tompkins.
To the member for giving way. For the record, Presiding Officer, my amendment on the Charter of Fundamental Rights reads as follows. The Charter of Fundamental Rights continues to have the same legal authority in Scots law on and after exit day as it had on the day before exit day. It is an amendment designed to provide continuity, not change, in the legal status of the Charter in Scots law.
Christina McKelvie.
Always in points of law there's an interpretation. My interpretation is that you give no force in Scots law to the Charter of Fundamental Rights via your amendment. And that will be up to the Finance and Constitution Committee to decide that later. But I would urge them to take the lead from the Stonewall briefing and to reject Amendment 98 on the same grounds that they urge the Lords to protect the Charter of Fundamental Rights in the EU Withdrawal Bill of the UK. Now we know that the power grab that we feared in Scotland is coming true. It's been all admitted by the UK Government. It was published, a list of 24 devolved policy areas it wants to keep control of after Brexit. We know the power grab is now officially real. They've not got an answer for it. But the UK Government has never been that good at following its own advice, which is why we need to work things out for ourselves. There's a memo going around the Cabinet, I understand, that recognises that there is no argument against the claims of a power grab on Scotland's devolved powers. They've got no argument whatsoever. So that's why we need the continuity bill in Scotland. And the continuity bill comes into effect if the Scottish Parliament decides not to consent to the EU withdrawal bill. We have tried to work with the UK Government and UK-wide legislation, but they won't have it. They keep letting us down. Promises made, vows made are not delivered. So where should we go after that? We have no trust. It is within the competence of our Parliament, as legal experts, including the Lord Advocate of this land, have concluded. And it is the only way in which we can avoid that power grab. It is our protection against our devolved powers being withdrawn. When Britain leaves the EU, there are 111 powers and responsibilities in devolved areas due to be repatriated. The UK Government, in Clause 11 of the EU Withdrawal Bill, calls for all of those powers to go straight to Whitehall, for ministers to decide what should be given to MSPs and what should be kept in national frameworks. Crumbs off the dinner table. That cannot be allowed to happen. And if the intention is to retain these powers only temporarily, to bring it back to the Scottish Parliament, then why on earth is there not a sunset clause in the EU Withdrawal Bill in order to say that, to bring those powers back to Scotland, even if they want to hold on to them on a temporary basis? They've not done that, and I would urge Conservative colleagues here to urge their people in Westminster to make sure that protection is in place. And though we have some agreement between governments on around 86 powers, there is still no consensus on the remaining 24. These are important powers, such as agriculture we've heard about, GM crops, fishing, environmental policy, public procurement, state aid, food standards, animal health and welfare, food standards, hygiene law, food labelling and chemical regulation. And if Graham Simpson thinks that ordinary people out there are not interested in this, he should have been in this chamber on Saturday when we had the Women's Convention, International Women's Day, and listened to the questions of all of the women gentleman who asked me about the impact of the EU withdrawal bill. He should have been here that day. The UK Government believes that 24 should operate on a UK-wide basis and the Scottish Government being consulted on changes. The UK withdrawal bill suggests that they have a duty to consult, not a duty to get consent. So, again, where are we getting this agreement? Because we are not getting that agreement. And the UK bill amendments in Clause 11, as I say, do not give respect to this Parliament. It says consult. It doesn't say agree. And that is a key factor for me, because if we do not get an agreement, then what should this place do? This place has a duty to protect what it has, protect its powers and protect the people of Scotland. And I would ask all the people on those benches over there to do that too as well.
Dean Lockhart, followed